Legs not to move my legs. This is the second case on the docket. It is case number 23-1382, Alberto Pardo Alvarez versus the state of Florida. Mr. Cerise, how much time would you like for rebuttal?
5 minutes would be all right.
All right, floor is yours.
May it please the court. Good morning, Your Honors. Eric Cerise on behalf of the appellant, Mr. Alberto Pardo Alvarez. This court should reverse the trial court's order denying Mr. Pardo Alvarez's motion to withdraw plea after sentence for the reasons stated in our initial and reply briefs. Although today I'd like to focus the court's attention on issues 1A and 1C as labeled in our briefs. That is, counsel's failure to advise Mr. Alvarez of the potential defenses that he had, the various defects in the charge's 17-count information, as well as his ineffectiveness in stipulating to a factual basis for the guilty plea as to the attempted kidnapping charge. I can take each of those issues in turn to the extent that the court has any questions otherwise.
Well, actually, I'm going to take them in opposite order. Because it seems that the factual basis on the attempted kidnapping is a major concern of yours. Having dealt with you and this firm before, I know the quality of the research that you all do, so I'm sure you're familiar that I've written on this topic on a number of occasions.
In fact, Your Honor, no, that would be news to me.
Right, well,
was it specific to attempted kidnapping or just the concept of what constitutes attempt?
Overt act.
Right.
In Berger versus State, Fish versus State, the overt act here. You've got an individual who has been, breaks up. It was a bad breakup. She gets injunctions, and so he has in his car, he's following her. He rents a car, so he doesn't know where she's living at, but he is able to track her down. And in order to, I think it's a fair inference that in order to avoid detection, he rents a car so that he's not using the car that he normally drives. And within that car, I'm trying to look and see what he had, rope, duct tape, razor blade, a gun which turned out to be, an airsoft gun. So he's had to go and purchase or at least put together all of these tools of the trade, so to speak, and he's going to her where she is staying, hiding out from him. And then he flees from the police. Why isn't that sufficient to establish an act towards the commission of the offense?
Well, I appreciate you hashing out all the facts that are relevant to it, because that's what this is. Determining whether an overt act or the actions amount to an overt act is fact intensive, and it changes in every case. So the court doesn't have to draw a specific line in this case. But I don't think that arises to the overt act, because it doesn't come close to completing the offense. And we use the case.
That's not the test.
Well, but if you look to the Enix case that we cite in our brief, the court uses language that the act must reach far enough toward accomplishing the desired result to amount to commencement of the consummation of the crime. So it has to come far enough toward accomplishing the desired result. And in the facts of this case, Mr. Pardo Alvarez was merely in the preparatory stage. He had admittedly gathered items that could provide an inference, but those are all more so focused on the intent element of an attempted kidnapping rather than the overt act element that's required to be proven. And so without that overt act, Mr. Pardo Alvarez's trial counsel was ineffective in stipulating to that plea, to that factual basis, because as the Williams court in our brief notes, in order to be able to stipulate to a factual basis, there has to be factual information necessary to establish each essential element of the crime. And that's what's missing here. The overt act at best was the preparation. So let me rephrase that. At best, there was only preparation, and so there was not an overt act sufficient to establish an attempt here. And I think, Your Honors, if we look at the facts of this case and the history of it, I think at best this was a stalking situation, not an attempted kidnapping.
Well, most people who are stalking don't carry duct tape and ropes and razors and guns in their car.
No, Your Honor. Although I will say there was testimony below at the hearing on this motion that those items in the car actually had a reasonable purpose.
Of course they did.
I don't know if I can come up with a reasonable purpose for the airsoft gun, but the other items that were found in that car, there was testimony that the realtor that was advising them to sell their home as a result of their divorce had advised him or given him a list of things to gather in order to get the house prepared for sale. So I think the reality, though, is that
if this is a stalking case, ultimately speaking, and we credit your client's testimony, I'm sorry, Mr. Andrade's testimony as the trial court did, that your client never wished to go to trial. Let's assume for the sake of argument that count 2 completely drops off the table from a sentencing standpoint. What's his maximum exposure to the remaining counts?
well, if you're still keeping count 1 on there.
Because it was no cost.
Well, right, but if we're talking
Follow
about
me this way, that if you look at the maximum exposure, you drop count 1, which was no cost, you assume for the sake of argument that the state wouldn't have been able to prove count 2, which I don't know, especially based on my colleagues' questions, is a settled fact, but I understand it's the argument that you're making. How many years exposure does he have for the remaining 6 counts? Right. It's 15 plus 5 plus 1 plus 1 plus 1 plus 1. It's 24.
okay, my number was 20. Yeah.
So, and I didn't mean to make this a math problem, my apologies, but
No.
it's 24. So if we take his maximum exposure for what's left and credit Mr. Andrade's testimony as the trial court did, that your client never wished to go to trial, is 14 an okay deal at this point? How do we weigh that?
Well, I think the reality is that Mr. Andrade never adequately discussed what those sentencing ranges would be if some of these charges and the bulk of these charges were no longer at play. So the testimony showed that Andrade was advising his client over and over again, I think he testified some 50 times, of what these charges faced, the maximum penalty, and what his maximum sentencing range would be, which was 14 on the low end all the way to life. But when you take out some of these charges and you advise your client that several of them are likely to either be sentenced or would even prevail at trial, and we can get into some of the specifics of that as well. Now we're talking about a sentencing range from, our math shows, anywhere from 5.5 years to 31 years, depending on which charges actually prevail. And that's significantly different than advising a client that you're facing anywhere from 14 to life. And it's that lack of substantive advice in the plea stage that caused Mr. Pardo Alvarez to enter an involuntary plea because of the result of an ineffective assistance of counsel.
Yeah, it just seems that it's really tough. I always observed what a really hard job defense counsel had at the trial level, because they don't really have much of an idea whether, a jury's going to come back yes or no on a lot of issues. They don't know whether or not a trial court judge, if those things do come back guilty, whether they're going to run consecutive or concurrent.
Sure.
But it seems to me that it might be tough with an aggravated stalking where there were multiple instances of it, that it might be a guarantee that they be run concurrent. I see what you're saying, but it's...
Yes, and that was under the theory that the sentences would be stacked, correct?
Yeah.
Although, going back to that first issue of not being properly advised of some of these procedural defects, some of the substantive defenses that were applicable, the testimony is clear that Mr. Pardo Alvarez was not advised of an applicable defense of abandonment.
Whose testimony was that? Counsel's or your client's?
A little bit of both, Your Honor. Our client testified that he was not advised of that defense. The testimony from Andrade, the trial lawyer, is a little unclear, although he did testify that he did not recall whether that defense was discussed with his client. But more importantly, when you look at Judge Tom Young's analysis at the hearing, he certainly treated that testimony as if it had never been discussed, because one of his findings that we really dispute is that the lack of advising Mr. Alvarez of the abandonment defense was not by
Whose
itself
testimony
enough.
was it? It was Mr. Andrade's, I think, that said that your client had said all along, I specifically didn't have the intent to kidnap her, I didn't have the intent to murder her, I didn't have the intent to stalk her, correct?
Yes.
Is that inconsistent with an abandonment defense?
Well, I think the inconsistencies are part of the consideration, but I think the real inquiry is what was Mr. Pardo Alvarez advised of during this plea stage?
Right, but if his client is saying, I didn't intend to do it, I didn't intend to do it, abandonment is a defense or an avoidance, assuming that he did intend. So how does it fall into the realm of ineffective assistance if you're taking your client at his word to say, I didn't have the intent? Why is abandonment necessarily on the table with that?
Well, I think there was always a consideration, and Andrade recognized this, that the case would go to trial. It's in the record that he moved to sever counts 1 and 2. He was definitely prepared to go that route if his client decided he wanted to go that route. And if that was decided, if that was the chosen path, yet he did not discuss an abandonment defense with him, the legal effect of that is that once Pardo Alvarez decides, you know what, I don't want to take the trial route and I want to plead, he's not realizing that he has an available defense that he's waiving. And that's what the Williams case is.
Why is it an available defense if the client is specifically saying, I acted in a way that doesn't lend me to use that defense?
Well, I don't think, I think the client's understanding of how the case played out and what would be required in terms of legal evidence to prove the case, I still don't think that necessarily forecloses his claim that he wasn't adequately advised.
So does a criminal defense lawyer act ineffectively? And let's take a possession of a firearm sort of case where the client unequivocally says, I didn't have a firearm. Does a criminal defense attorney act ineffectively by not discussing a necessity defense, which assumes that you did have the firearm and that you needed to use it?
I think that situation is different, although I recognize the court's concern that Pardo Alvarez's insistence on not, that he didn't have that intent changes the type of advice that Andrade might give to his client. But the reality is that Mr. Pardo Alvarez was time and time again told that he was facing 14 years to life in prison. If Andrade had taken the time to vet some of these deficiencies in the charges, if he had explained to his client that counts 1 and counts 2 are likely to be JOA'd, counts.
Well, but that's a big assumption that count 2 was likely to be JOA'd. And based upon, the questions I've asked you and some of the writings that I've done on this topic, I'm not embracing that. I think that, I forgot to mention the latex gloves, excuse me.
Close ways.
Yeah. That's a case that if you're looking at it from a defense attorney point of view, don't you think that case can get to a jury?
Possibly, Your Honor. Although the real misstep here is going the next step with his client and showing him if these cases are not going to get through, if they're going to get JOA'd, or if there's insufficient evidence to prove them, the resulting maximum penalties are drastically different. So if you're told that you're facing 14 to life, but if counts 1 and counts 2 are likely to be JOA'd based on the case law,
How can this lawyer make an assertion that count 2 is likely to be tossed out? I mean, is it ineffective assistance of counsel for him to have looked at these set of facts and to say, well, I can't have any real promises to you that count 2 is likely to be JOA?
No, I mean, I think
because we're looking at this through the lenses of ineffective assistance of counsel following entry of a plea.
right. But I think the real ineffectiveness is at least giving him that scope, that range of sentence, because otherwise he's just being told that he's facing the maximum exposure. But it's a different calculus when you're told that if these cases do not get to the jury, or if we successfully win a JOA based on the case law, that your sentencing range is anywhere from 5.5 years to 31 years. And that's just a different scope. That's a different calculus. And that's what Pardo Alvarez lacked in his decision-making leading up to this plea. Your Honors, I'm getting close to my rebuttal time, so I'm going to reserve the remaining 5 minutes for rebuttal. Thank you.
Good morning, Your Honors. May it please the Court, my name is Dan Caldwell with Attorney General's Office. I represent the state of Florida in this matter. The Court hit most of the points I wanted to, but there's one very important point that has not been highlighted. It's something I missed until I was preparing for this argument. There was a factual error made by post-conviction counsel at the evidentiary hearing, which has carried over into this brief and is carried through today, that further undercuts the assumption that there was an abandonment defense to counts 1 and 2. What actually occurred at the hearing, post-conviction counsel argued, appellant was driving behind Ms. Vargas, who was going to work, being taken with a friend, when law enforcement got behind him, but they were in an unmarked vehicle. He didn't realize that law enforcement was behind him. He made a U-turn, hence abandonment. That's not actually what happened. When you read through the affidavits that the court relied on in its factual basis, the victim was being taken home by her daughter on either the 29th or the 30th of January, and a gray, or she described as silver Nissan, got behind them. They pulled over, let it pass, and they saw appellant driving. They called the police. The next morning, it was not Detective Atkins, it was Officer Lopez, who was at 7 a.m. at the victim's apartment complex. He saw not a silver, but a gray Nissan drive by the apartment slowly several times. At 7:30, the victim's friend arrived, picked her up, they started to go to work, and Officer Lopez followed. As he was following the victim, he then saw, according to his affidavit, which is the record, page 283, he then saw this gray Nissan passing in the opposite direction. It did not have tinted windows. He looked, he identified appellant, and it was then the officer who made a U-turn, notified dispatch, and waited for additional units from Air 1 to get in the area, whereupon he tried to perform a traffic stop. Now, it's true his affidavit does not state whether or not he was in an unmarked vehicle, but he did say he activated his red and blue lights, his siren, on his agency-issued car. So the U-turn...
I'm struggling with the difference. If he's going in the opposite direction, doesn't that presuppose a U-turn?
The officer made the U-turn, Your Honor, because the officer was following the victim.
But if the officer is following the victim and the car goes back the other way that has Mr. Pardo Alvarez in it, can we assume that he turned around?
At some point he did, but the officer had seen that exact same car, which was described by the victim as following her the day before. That car had driven slowly by her apartment complex several times this morning and then left. As he was following the victim to work, that car was returning. So the state's argument is there's definitely an attempt here, because it was the presence of law enforcement that caused appellant to discontinue his following of the victim, and he fled as soon as they activated their lights and sirens, and which brings up Your Honor's point, what was found in his vehicle when he was stopped. So this is simply to undercut this assumption that any competent counsel would go to their client and say, you know what, we've got charges 1 and 2.
Well, but the attempt has to be for the commission of a kidnapping, not for a stalking or violation of an injunction.
Yes, sir.
Is simply the purchase of tools of the trade sufficient to sustain a conviction for an attempted kidnapping?
In light, I think that's the whole reason that defense counsel or trial counsel tried to sever the charges, because when you consider those items on their own, then perhaps not. But when you consider a threat to kill followed by an injunction, multiple violations, an arrest, and then when he bonds out, he still violates. And when he's found, he flees from police. He has what appears to be a weapon turns out to be a BB gun, that 4 different sizes of rope, 2 box cutters, gray duct tape, CO2 cartridges for a BB gun, BBs for the BB gun. That definitely.
Don't forget the latex.
And the latex gloves, correct. And as to the argument that this was all in preparation to sell his house based on a flyer he received from his realtor at the evidentiary hearing, that was entered in.
Forgetting, I was cleaning out my house, cleaning out my garage. Where do you legally draw the line from preparation to attempt?
That but for the intervention of law enforcement or some intervening event, the criminal act would have occurred. So the argument is he's been stalking the victim. He's then going back towards her house, and the officer sees him. So the officer gets behind him and stops him. He's got these implements in his car. The argument is he was continuing to stalk her. He was continuing to case her house. He was getting her schedule down. He'd been seen at her apartment. He'd been seen at her work. So and he has these tools in his vehicle. So, but for his being arrested by law enforcement that day, a kidnapping would have occurred, if not even necessarily that day. One was definitely going to occur in the future.
So he was in the process of attempting to kidnap.
I think he was waiting for the proper opportunity, Your Honor. I don't think he picked a specific day. Why else would he be driving by to see where she is? So is he lying in wait? Probably. Is he biding his time? Is he waiting for the best time? That's the state's position.
Is the question here whether counsel was ineffective in not exploring that further?
No, Your Honor. The question here is whether or not a manifest injustice has occurred by counsel advising appellant what he was facing and whether or not he should plead and allowing him to plead. Even though they do tend to overlap, as the trial court pointed out, that there is some ineffective assistance of counsel analysis to be applied to this. The question is, was there a manifest injustice? Is there a firm and abiding conviction that a mistake was made below that such that the appellant suffered prejudice?
Yeah, but isn't there case law that says if there is no factual basis for a crime, by definition, that's manifest injustice?
That I'm not aware of, Your Honor. I'm aware of case law that states that, of course, you can challenge a factual basis, but it's the state's position there is a factual basis here. The court who took the plea was the same court who heard the evidence on the motion to sever charges.
That's also the same court that instead of having the state articulate a factual basis, turns to the lawyer and says, do you stipulate to a factual basis?
Correct, but the court also...
If they present a factual basis on the record, then we might or might not be, right?
Yes, Your Honor. However, the case law is also clear that the court can rely on whatever it wishes for a factual basis, and it has vast discretion on what it's going to rely on. And the court specifically said it, of course, has to point in its order or on the record to what it relied on. And here the court said it relied on the exhibits, which were the arrest affidavits submitted by the state, which detailed the original injunction, the threat to kill, the multiple violations, the arrest, until finally the arrest that was at issue in this case on January 31st. The court relied on that. The court had sat through the hearing on the motion to sever. The court specifically ruled on the record that, okay, these are all connected. These are all temporally related, all of these acts together. So I could understand if it was a judge who had no familiarity with the case, walked in and had not sat on any of the hearings, and in addition to the state did not submit any affidavits, that there might be a problem. But that's not the situation we have here.
Is the record silent as to whether on the prior incidents of stalking, whether he had these types of items with him?
Many of the prior incidents of stalking, he was not arrested. He was only arrested one prior time. Many of the instances were witnesses at the victim's work saying they saw him. So there's nothing to say he had them before. No, that's true, Your Honor.
In determining whether or not there's been a manifest injustice here, what weight do we give to Mr. Pardo Alvarez's testimony that he was actually guilty?
That's a credibility question that I believe the court had to give. It's a double-edged sword, because the trial court found that his testimony in the evidentiary hearing was not credible. However, the court determined him to be credible at the time of his plea, which is one of the factors the court would consider under the Grosvenor analysis. But also, again, this is why the appellate courts the case law always directs the appellate court to give great deference to credibility determinations made by the trial court at the time, because the trial court is sitting in court. The trial court sees the witness, listens to the answers. The court had no reservations when it took the plea. It found the plea was knowingly, intelligently, and voluntarily entered. The appellant said under oath he was happy with his lawyer. He explained everything to him. He explained what he was facing, and then he said something completely opposite at the evidentiary hearing, also under oath. And
Was this argument as to no factual basis contained in the motion to withdraw the plea?
I do not believe so, Your Honor. I think the no factual. I know that the argument was that, but for advice on the charges he was facing, that he would not have entered his plea. I cannot say one way or the other if that element was there or not, Your Honor. I'd have to defer to the record. So it is the state's position that the lower judgment should be affirmed in all respects, and that the motion to deny withdrawal of plea should be affirmed. And unless the court has further questions from me, the state will rest on its brief.
Thank you.
Thank you.
Mr. Sarista, can you answer that last question I asked?
Yes, Your Honor. The motion was amended twice and did not include an allegation in terms of the factual basis argument that we raised today. However, at the hearing on that motion, obviously Judge Young allowed that questioning and found that it was relevant under the claim that Pardo Alvarez generally was not advised of the fact that there wasn't sufficient evidence to enter the plea. So I think Judge Young found that it was still relevant under the claims of the motion, but it was not expressly contained in the motion itself. I don't think that forecloses the court's consideration of that issue today, though. The state cites to the prior injunctions as a basis to consider the sufficient evidence of attempted kidnapping. I don't think that's the proper inquiry. I think the prior injunctions might have been relevant to his intent and the intent aspect of that crime, but it still doesn't really provide any evidence of an overt act. What he was doing earlier in the month of January, stalking, going to her place of employment, that's not evidence of an overt act towards the attempt of forcibly abducting the alleged victim in this case.
When you have cases that involve the stings, I forget what the name, to catch a predator or something like that. Those cases involve situations where a person drives to a house, and the driving to that house is deemed to be sufficient for purposes of an overt act. Why isn't the fact that this individual is driving to this person's home, who's intentionally trying to avoid detection, why isn't that sufficient as in line with the other cases?
Well, because there's never a point in which there is an overt act to forcibly confine or abduct.
Well, and there's no overt act in the other cases to have sex with a minor.
No, Your Honor, although the case law in that is different. The case law has expressly found that in those types of crimes, the traveling to meet a minor cases, that travel is the attempt. This is kidnapping, which requires, I would say, more evidence of the overt act rather than just simply driving to the apartment complex. In addition to the prior injunctions being irrelevant to an overt act, I'd also point out that the specific dates that are alleged in the state's information on the attempted kidnapping charge are specific to a 2-day time frame. I believe it's January 28th to February 1st, which is in that date range of his final arrest. So we think it would be improper for the state to rely on prior injunctions and evidence prior to that specific.
Without a statement of particulars, the state isn't bound to those dates.
Understood, and we recognize that that could be amended further down if the case were to proceed forward to a trial, but the focus is on what the attorney at the time, and based on the evidence that he had from discovery, saw and knew. And in that instance, you can't rely on that prior evidence to stipulate to a factual basis. It's about what happened on the final day of that arrest and whether there was sufficient evidence there to establish an attempted kidnapping. The court was also questioned the state about the credibility determinations that were made in this case, and we do recognize that at the hearing below, Judge Young found that our client was not credible. However, we don't necessarily need to rely on anything but Andrade's testimony, because the testimony of Andrade clearly establishes that he didn't take the time to go through the 17-count information and talk about what case law supports the two most severe claims not likely going forward. What double jeopardy issues concerning the aggravated stalking cases and some of those other smaller misdemeanors that were likely invalid charges too. And so the testimony of Andrade that the court found credible still allows this court to find that we've met our burden of establishing a manifest injustice. And the final point I'd like to make is the state highlighted the plea colloquy that shows that Pardo Alvarez said he was satisfied with his counsel, he had no complaints. The Sanchez case that we cite in our reply brief notes that a defendant who doesn't learn of his counsel's shortcomings and deficiencies prior to that plea colloquy can't know the legal ramifications of that misadvice or that ineffectiveness. And so simply the answers that he gave at the plea colloquy don't automatically foreclose the claim of a manifest injustice in this case. So with that, I'd ask the court to reverse the trial court's ruling.
Thank you. Thank you both for your presentation. We'll be in recess.
Where are we going?
Oh, yeah, sure.